Who is yelling?
And Mr. Crowley, Your Honor, he declined to speak to Mr. Tizzo. Mr. Crowley, can you come up here to the door?
Sir, could you state your name for the record, please?
My name is James Crowley.
Mr. Crowley, you have the right to remain silent. Anything you say can and will be used against you at trial. You also have the right to an attorney. If you cannot afford an attorney, one will be appointed to you by the court of public expense. Sir, if you change your mind about the court-appointed attorney at any stage in the proceedings, you can ask for a court-appointed attorney, and the court will entertain such. All right, it is alleged that on February 3rd of 2025, while in the city of Taylor, that you committed the following crimes. In count one, it's alleged that you committed the crime of domestic violence and that you allegedly did make an assault or an assault and battery upon one Jennifer Marie Ashby, an individual with whom you've had a dating relationship. That's contrary to Michigan Compiled Law 750.81, subparagraph 2. That's a misdemeanor, punishable by 93 days in jail and or up to $500 in fines. In count two, it is alleged that you committed the crime of interfering with a crime report that you allegedly did through the unlawful use of physical force to prevent or attempt to prevent another person from reporting a crime committed or attempted by another person. That's contrary to Michigan Compiled Law 750.483, subparagraph A to A. That's a misdemeanor punishable by 1 year and or up to $1,000 in fines. As to those charges, I'm going to enter a plea of not guilty on your behalf. I'm going to set these matters for a pretrial, and you'll be given the date and time of when that pretrial will be. In the meantime, I'm going to set your bond at $2,000 personal, no leaving the state of Michigan without the consent of the court, no contact with the victim or victim location, no use,
Your Honor,
or possession of any weapons, firearms, or ammunition.
Your Honor, am I allowed to ask
What's that?
$2,000 personal bond? I don't know what that means.
That means if you don't show up, you owe $2,000 for the next court date.
Does that mean that I'm going to be released?
That means that you will be released on your own personal recognizance. That's what a personal bond is.
So it's a PR bond?
That's correct.
I'm sorry. That's what I know it as. I'm sorry. And I can't go, can I ask you this, Your Honor?
Sure.
Jennifer and I live
All
together.
right, so hold on. I don't, because I know you're already starting off with the first thing out of the sentence is the victim's name. There's no contact with the victim. So you need to have some other place to go because you got no contact with the Harold Street address right now or the victim.
Can I have a police escort me all my personal property, my phone, my wallet, my keys?
You can call it, you can, listen, it is not the responsibility nor the job of the Taylor Police Department to babysit domestic disputes when there's property swaps like that. But if you call them, they can do what's known as a civil standby. It is at their convenience because if they have something going on, if there's a case, a murder, you name it, whatever, that's, that they're doing, that's, you're going to lose out on as far as the priority level. But if they're available to do so, I got no problem with that happening.
Okay, thank you.
They gotta be there, but they gotta be there. So.
Well, you got my word that I'll show up to the court date like I'm supposed to, and I will abide by all law.
Sure, and don't make any contact with the victim. Don't have any third party contact. Don't have anybody make contact for you. You understand?
Oh, okay. I know if I have to contact her for my belongings, I'll go directly through the Taylor Police Department.
Well, you can, again, that's not going to be their job to do that either.
I know.
Listen, sir, I'm just telling you right now, the only person who I will allow for you to make contact with her is if you hire an attorney who then can reach out and you make sure the attorney is aware of the bond conditions and that you can only do that just for possession, swapping type stuff. I don't know if you have kids together or not, but for this situation, if you have an attorney, because the attorney is actually somebody who is an officer of the courts here in Michigan, they'll know how to conduct themselves and they will not be passing on any hey, can we get back together? No.
Yeah, we'll be professional. We're not going to act like a bunch of children.
So exactly. And then that way they can just contact her as far as what a date might be possible. And then again, of course, it's also got to be conditioned on Taylor Pete available.
You'll never hear from me again. Yep.
Well, we'll see you at the pretrial though.
You'll see me then. That's it. I will show up.
All right, sir. You have a good
Thank
rest of your day. Officer Ziegler, have a good rest of your day.
Thank you, Charlie, as well.
Thank you.
People versus James Crowley. This is the prosecutors requesting an adjournment on the case. Mr. Crowley, a new notice will be sent to you. All right, yeah, your bond is continued. Looks like a $2,000 personal bond, same bond conditions.
Yes, Your Honor.
Do you have questions?
I do not, Your Honor.
Wait, hold on a minute.
We have complaining witnesses here for this case. The complaining witnesses are in the courtroom.
Oh. Do you have questions?
No, I just want to make sure that the no contact is in order.
The bond is continued and it was previously a no contact provision.
That was broken.
It was broken?
Yeah. That's why we're adjourning. That those documents can make it up to the court system so that we.
Well, we need to have the prosecutor address this then.
James Gazicki on behalf of Mr. Crowley. Prosecutor's asking for an adjournment, Your Honor. So we will stipulate to that.
So I don't have a problem with that, but there's the victim is in the courtroom and she said something about a violation of the bond conditions. So I need to address that.
Your Honor, the report that's in the file indicates that Child Protective Services contacted her. I don't think that'd be considered a bond violation, Your Honor. He's got a right to notify proper authorities if he believes it's in the best interest of the children and so on. So I would ask the court just to continue the personal bond. He's aware that neither he nor any other person can have contact with the victim in this case.
Your Honor, the bond violation allegation in this case is not regarding CPS. It is regarding a third-party contact that was allegedly made by Mr. Crowley to a Ms. Shiloh Hickey, allegedly telling her that to talk to the complaining witness and tell her that he will come after her. And both the complaining witness and Ms. Hickey are here today.
Your Honor, we asked for a hearing on that. That's the first that I'm getting facts concerning that violation.
May I speak on that in defense right now?
No, don't speak, Mr. Crowley. Don't speak.
Well, I'm honest. I'm honest. I ain't got nothing to hide.
Mr. Crowley, I'm advising you as your attorney, because anything you say can be used against you.
I'll say
I'm
the same
asking
thing.
for, I'm asking for, Mr. Crowley.
So, all right, I guess we'll go back then to Crowley. And
Yes, Your Honor.
so,
We're
yeah,
ready.
Mr. Gazicki, are we having a hearing on a bond violation? Is that where we're going?
Your Honor,
with
we'd
it?
have to. I'd like this third party to come in and testify. Mr. Crowley did not authorize anyone to talk on his behalf. This is a blatant accusation. As the court noticed in the file, you got a case here where the victim's upset because Child Protective Services contacted her. So I would like definitely a hearing on this, Your Honor.
And Your Honor, a report was made and I did request that it get sent into the court, although I'm not sure if it was.
Well, there's something about the contact with Child Protective Services, but I think, is there also an allegation that third party was asked to, through Mr. Crowley, to make contact with the victim?
Yes, Your Honor, there is. And again, I did advise the complaining witness to make a report. I am aware that she did, but I don't believe it was sent into the court, although I did request it.
Is that complaint, is the third party here today?
Yes.
Do we want to take testimony on that?
Uh,
Where do you want to go?
We are ready to do that if that's what the court.
So the third party is here, Mr. Gazicki and Mr. Crowley, and the prosecutor's prepared to move forward with this.
There is the third party here.
Yes.
The third party. Well, if the court wants to do the hearing, we'll do the hearing.
Well, I think
I
we
don't know if you need
should.
Mr. Crowley in person or we're gonna do it by Zoom or what.
Well, I mean, we could do it later this morning if Mr. Crowley wants to come into court.
I'm in Port Huron, Michigan, Your Honor.
Well, it's important. I think we address this today.
Well, we can do it right now. If you feel jail or anything is the best place for me, really, Your Honor, I'll come in. I'll uphold my word.
All right, well, let's,
Because I didn't do this, and I want my name cleared. This shit's retaliation. I want it dismissed. But hey, okay.
all right, so yeah, let's hear from the witness then.
Would you like to start
The
now?
third party, yeah.
Okay, so the people call Ms. Shiloh Hickey. Right, could you please state your name again for the record?
Shiloh Hickey?
Ms. Hickey, do you know a man by the name of James Crowley?
Yes,
And do you see him today here in the courtroom or on Zoom today?
on Zoom.
Okay, and let the record reflect the witness has identified the defendant. And did you make contact with Mr. Crowley recently?
Yes,
Do you recall what day that happened on?
depending on which one. The day of the incident of which he asked me was the 18th of March, this
Okay.
month.
And what
What
city?
day was it?
The 18th.
Okay,
The only reason why I know the date exactly was I was supposed to take my brother to take his car into the shop and I didn't make it, but I still ended up coming by his house the same day.
And Ms. Hickey, so allow me to ask you the questions and answer the questions that I asked. So it happened on the 18th of March. Where were you on that day?
At my brother's house in Romulus.
Okay, and is that in the county of Wayne?
Yes,
And what did Mr. Crowley tell you when you made contact with him?
we were talking about how he was having problems with Jen and that they were going to court. And we started talking more and he's like, yeah, I need this case dismissed. He's like, I need you to do me a favor. He's like, I need you to do whatever it takes necessary to get it dismissed. I was like,
And then, so you said Jen, can you tell me who you mean when you say Jen?
Jennifer Ashby or Craven or whichever last name that goes by on like paper,
And what did he tell you next?
just to do whatever it took to get the case dropped. He's like, but I don't want any details on it.
And what did he say after that?
He's like, just let me know. That's it. And expecting me to take that as it was.
And did he advise you to speak to Miss Jennifer Ashby?
Yeah, either that or to get one of my friends to do it, so that way he couldn't be connected because I'm his cousin.
How, and what did he tell you? And how did he tell you to make contact with her
To go up to her job,
and do what?
get her to drop the case, whatever means necessary.
And did you do anything after that?
No.
And did you ever make contact with Miss Ashby after that?
Yes, on the 24th of March to warn her about what was going on.
Okay, and what did you tell her?
That Jimmy asked me to do whatever was necessary to get her to drop the case and that I was worried about her and that she should definitely be looking over her shoulder because he's having a mental breakdown and I don't know what's wrong with him.
Okay, and just to clarify, where did you make contact with her?
I tried to go to her job and she didn't answer, and then I contacted her on the phone and called her. I didn't think that she'd answer my phone at first, that's why I went to her job. Because everything that was going on and with me being Jimmy's cousin.
Okay, and let me stop you there. Did you only make contact with her by phone or?
I didn't see her at her job, no, I made contact with her over the phone.
Judge, the people are satisfied. So we would ask that you think and excuse this witness.
yeah, Mr. Gazin,
I'd like to ask some questions.
Oh, I didn't see him in here, sorry.
snuck in on us.
Okay, Miss, your last name is Hicks?
Hickey.
Hickey?
Mhm.
Okay, and you stated that back on the 18th, you were at your brother's house
Correct.
with Mr. Crowley there?
Correct.
Who's your brother?
Casey Hickey.
Do you know if there's any kind of court proceedings taking place between your brother, yourself, and Mr. Crowley?
Nothing to do with myself, but I have no idea between the two of them.
All right. And you said on the 18th that when you were talking to Crowley, Mr. Crowley stated that he wants to get this case resolved, whatever it takes, right? Correct? Did he say anything else?
No, just said to do whatever it takes necessary.
Right. He didn't say anything that he's gonna shoot anybody or hurt anybody or anything like that, right?
He has a history of.
No, did he say anything about,
Incriminating himself? No, thank you. I
Okay.
appreciate that.
so that's all he made a statement that,
Asking me to do whatever it took necessary to get her to drop the case.
Mhm.
Are we living in reality?
so you waited, you're worried about, was it Miss Ashby?
Yes.
And
more
and you
worried for
waited
his son.
6 days to tell her?
When he popped his lid and went nuts, yes. I didn't think he would actually
Well, no.
do something.
This happened on the 18th, you had a discussion.
Correct.
And then on the 24th is when you said this to,
Yes, because I knew he finally lost it and I was worried for her.
and one more time, I want to ask you, you don't know of any kind of criminal complaints being made by your brother or against your brother with Mr. Crowley?
Yes, criminal complaint, but not court.
What criminal complaint?
They got into it and got into an argument,
And when was that?
the 24th,
The 24th.
correct. It's not that,
So on the 24th, this is when you decide to tell
yes.
Ms.
because
Ashby, but prior to that, you didn't think nothing of it, right?
Yeah, because I didn't.
I got no further questions.
No, we're not doing that.
I just want to speak first.
No.
Mr. Crowley, please, Mr. Crowley is recording with his phone on Zoom. I don't know what the intent is behind that. It's already recorded. We are, again.
I'm gonna clarify what I said.
Just wait till you spoke, please.
Mr. Crowley, are you
My statement,
recording
please.
this? You're muted, Mr. Crowley. Mr. Crowley, you're muted.
No, I'm home alone in my bedroom.
Right, that's why you
Have
said.
you been
you're like,
recording this?
No,
This-
I have not been recording.
Did
I've
you
not
have
been
your
sitting
phone?
here. No, yeah,
Did
my
you have-
brother, yeah, my brother, yep. Is that against, I hope that's not against the law or anything. I did, my brother was in here. Hang on, I'm not lying about nothing. He did have he had his phone out and was recording. I did not. He said he's apologizing. I didn't notice he was there behind me. He probably had my best interest in mind, but we'll destroy it right now.
Okay, so.
Sorry
yeah,
about that. No.
What's your brother's name in case they want to prosecute your brother for doing that?
Oh my God. Well, can I take full responsibility, Your Honor?
You know, well, what's your brother's name, Mr. Crowley?
His name is Lee Evans.
Who's with you and what's his name?
Lee Evans Jr. That's just,
Ray?
that's it.
Ray Evans Jr.?
No, Lee Evans. Lee Evans Jr. And let me take full responsibility for this, Your Honor.
So, all right, Mr. Crowley. All right,
'Cause
so
I'm
that video, go ahead, did you want to say anything about the alleged video?
Yeah, can we?
Your Honor, are you speaking to me?
Yes.
I did just see in the Zoom right now on the camera, there was a phone on his screen and it appeared like he was recording. Again, given the allegations in this bond violation, it does appear to be that you intimidate people trying to record them. I don't know for what reason, but again, these victims are in fear.
All right, so, yeah, you need to delete that recording. Your
All
brother
right, we'll
needs
make sure, yeah, we'll give it up. We'll let a tech prove that it wasn't copied or everything. We'll bring in whoever we need to bring in to prove that we're honorable people over here. Lily, stop it.
All right.
Yeah, no problem at all. I'm sorry for that in any way. I mean, no disrespect to the court, Your Honor, or to the people.
You not understand how that could be considered intimidating?
No, I absolutely, yes, I do. I definitely do. I'm in my own room. You know, I don't mean to create intimidating. I mean, you know, that is my family.
You understand that this is a domestic violence charge, which is by its nature intimidating charge.
Your Honor.
And that behavior just is consistent with, you know, the charge.
Well, I'm sorry to even give that propriety. The impropriety of that alone, I apologize for. But I'm scared to death. That's a lie. And my
You and your
cousin is
brother
lying on me.
consider, could I stop you for a moment? Would you and your brother consider standing in the court?
I'll take a polygraph, will you?
Would you and your brother consider standing in the courtroom videotaping a witness appropriate?
Well, yeah, I would, because I believe
You
that
would?
any evidence,
All
yeah,
right.
because
You
anything.
Would you like someone videotaping your testimony while you were in the courtroom?
Yes, I would allow that.
All right, so that's a total misunderstanding. You cannot do that. That's considered very intimidating. You
And I
cannot do
apologize
that
to
without the authority, and you can't do it without the authority of the court. You understand
okay.
that?
I do, and nothing like that will
to
ever
me
happen.
would be common sense, and you're basically in a courtroom. Although we're allowing you to do this remotely, you are basically in the courtroom, and your behavior needs to comply with courtroom behavior and decorum. And that
Yes,
means
Your Honor.
not walking around when you're talking. It means
Yes, Your Honor.
standing still, and it means not recording unless you're given permission to record.
Yes, Your Honor.
All right. All right, so anything further with the witness?
Yes, just a brief redirect.
Yes.
So on cross examination, you had said something about an incident involving your brother and Mr. Crowley. I wanted to clarify, what date did that happen on?
The 24th. Now, when that happened.
I want to ask the questions. Prior to that, you had indicated you first made contact on March 18th with Mr. Crowley. Why was he at your brother's house that day, if you know?
Because he was, he had his stuff there and he had been staying there because the domestic violence dispute between him and Jet.
And then an incident had happened between him and your brother on the 24th. Which is after
Correct.
the 18th.
He had, I'm assuming, a mental breakdown, broke down my brother's door at 5 o'clock in the morning, and my brother drew a pistol on him, and then they proceeded to have a fist fight. So that had over Jennifer. He accused my brother or one of his friends of sleeping with Jen, and then caused a big argument and a big fight.
No further questions, Your Honor. No further questions, Your Honor.
And I got a follow-up question.
Sure.
Where did this take place at?
My brother's house,
Where's that?
Romulus.
And he
then I
pulled a
feared
pistol,
for
he
Jen,
pulled a
and so
pistol.
I went to
Ma'am,
her
would you
room.
answer my question, please? Your brother pulled a pistol on Mr. Crowley.
Right, after being woke up in the door.
And you, Your Honor, would you
answering
instruct the
your question.
witness?
Yeah, so, all right. Ms. Hickey,
I'm answering the question.
all right, but we don't argue.
I'm not arguing, I'm telling you.
You're arguing with me. You are arguing with me right now. Okay? And I know this is an intimidating situation, and I know it's uncomfortable, the fact that you're in the middle of this. But the fact is the way this, we can only record one person talking at a time. And the procedure that is used in court is question and answer. Okay, not question and argue. Question, answer best of your ability, okay? Don't speak over him and don't argue with him. And if you can't answer the question, say you can't answer the question. But we can't have you arguing, and we can't have you both talking at the same time, okay? All right.
And on that date with your brother, you indicated that Mr. Crowley destroyed some of your brother's property?
He broke down the door.
Yeah. And there's no criminal charges emanating out of that incident?
Objection, Your Honor. It's not relevant at this
Oh,
time.
it's very relevant to the credibility of this witness, because Your Honor, first of all, if I may, they have a conversation on the 18th. She waits 6 days before she talks to the complainant in this case, but she doesn't do it because of concern. Apparently, Mr. Crowley and her brother get into an argument, so this is in retaliation of whatever happened there. And there's a lot to that incident. You got one person pulling a pistol and another person supposedly breaking a door.
I'll let
I
you
don't know what
answer
happened
the
there.
question. Remember the question?
No, but I.
Al will rule the object. Question is there a criminal case pending in Romulus over this?
Not that I'm aware of, no, it was dropped.
I have no further question, Your Honor.
I have a question.
Well,
You guys
don't
see-
have to ask, you're not asking questions.
Well, I have something to say then. You guys keep saying that this
Objection,
is
Your Honor,
retaliation.
to the
Well,
narrative.
It's not.
I'm not
If-
sure.
I thought he was crazy enough to do that to my brother. What do you
You
think
know,
I thought? he was
we
doing?
don't want your opinion, really. I mean, we're trying to deal with facts, okay?
I'm telling you facts. I will take a polygraph.
All right, but the prosecutor, if you have any more questions. If she doesn't have any questions, they're gonna have you step down.
Just a couple. I can
Yeah.
briefly just get this over with. So, on the day that the incident happened with your brother, why did you decide to talk to Ms. Ashby?
Because I was afraid for her.
Did something happen on that day that made you more concerned?
Because when I got there, everything in my brother's cash and otherwise was gone, and I had a feeling he was running. So my first thought was he was gonna do something to Jen because there's no one fucking there to stop him now.
And then after that, did you go to Ms. Ashby to speak to her?
Yes, I went to her job to try to find her, to warn her what's going on.
No further questions.
All right, anything further?
No, yeah.
All right, thanks for coming
Let me
in.
just ask you two
Appreciate
things.
that. Yeah, you can step down. Okay. All right, well then, this is regarding the bond violation. Do you want to have any further argument on this testimony?
Yes, Your Honor. First, the complaining witness in this case is in a lot of fear of what's been going on after this incident date that we are here for. The witness testified today that the defendant had told her to tell the complaining witness to drop the charges on this case. An incident had occurred and she became more concerned and she went out to tell Ms. Ashby. And now Ms. Ashby is in a lot of fear. This goes against the third party provision in the no contact order, which says that the defendant cannot have third parties reach out to the complaining witness to ask them to drop the charges. And we would ask that you find the defendant guilty of this bond violation.
All right, yeah, Mr. Gazicki, any response?
Yes, Your Honor. First of all, as I indicated before, and it's evident in the file, that the victim or complainant in this case complained about Mr. Crowley contacting CPS. All right. Now we got a situation here where a witness, Ms. Hickey, comes in here and testifies that on the 18th they have a conversation. Nothing is done on that. And she indicates, she made her statement on what was, transpired on that day. Nothing is said. But back on later on the 24th, her brother and Mr. Crowley get into some sort of situation, and out of retaliation, this is all of a sudden now, how can I get even? She goes running to the complainant in this case, saying, oh, he said this, he said that. Your Honor, the witness's demeanor on here sounds like a person that is, in my opinion, very vindictive. I asked a question, but she had to have her own say. Your Honor spoke to her, she had to have her own say. This is a woman that came forward. This is a woman that came forward, like I said, just out of retaliation of what transpired between her brother and Mr. Crowley. And if this was such a big concern or something, and if what she says is true, I can't see a reasonable person waiting 6 days to tell the complainant in the case. So I would ask the court not to violate the bond conditions and just let them remain on personal bond.
Any response?
Yes, Your Honor. The incident that happened between the witness witness's brother and the defendant is only relevant for the reason that after it had happened, she had reason to believe that the defendant would do something to the complaining witness. He had advised her prior to that date to tell the complaining witness to drop the charges. And when the second incident with her brother had occurred, that is what placed her in fear for the complaining witness's life, which led her to speak to her. And I also want to remind the court, I mean, what just happened in court today with the seemingly intimidating act that the defendant has done. The complaining witness here and the two other people that she brought with her today are in a lot of fear of the defendant. It's very clear that he seems to be the vindictive one, the intimidating one. And again, we would just ask this court, I think, guilty.
All right, so, no, we're not, no, Mr. Crowley, we're not, I don't know, if the attorney wants to call you as a witness, Mr. Gazicki?
We're good.
He's not calling you as a witness, and so I'm not, you've got an attorney to argue for you. All right, so, yeah, why the witness? The burden of proof is on this a preponderance of the evidence. And the witness was credible. Date and time and location of the discussion regarding with Mr. Crowley indicating do whatever you need to do to get the case dismissed. I believe that statement was made, and that would be a clear violation of the bond. Why she didn't notify the victim immediately, I don't know. There could be multiple reasons. I mean, sometimes people are asked to do things and they make their own decision and say, I'm going to do it or I'm not going to do it, but I'm not going to get involved any further. You know, she could just say, listen, I'm not going to do that and let it go at that. Maybe, but I'm not going to second guess why she may or may not have done it sooner. But I believe that her testimony was truthful, and by preponderance of the evidence, I find a bond violation, a serious bond violation, Mr. Crowley. This case is going from bad to worse for you. You need to let it run its course and follow the court's orders, and that's extremely important. Asking a third party to intimidate a victim is totally in violation of the bond, in my opinion.
I'm not guilty of that, and I didn't ask her to do that.
I hear what you're saying, and I've ruled differently. All right, so any recommendations?
Your Honor, I would not, I'm no.
Mr. Crowley, quiet.
Your Honor, just that the bond be revoked.
So,
Yeah, and if I may address that, I disagree with it, obviously. I mean, this is something, you know, like I said, six days she waits. You know, they may have had a conversation that, hey, you know, whatever it takes, I want to get this done. But you know, he didn't tell her, go over there, you know, slit her throat, put a gun to her head and all this kind of stuff. Nothing like that. I would ask the court, just in this case, Mr. Crowley is well aware that he's got to watch who he talks to, what he says, and so on. You know, and again, this matter is being adjourned instead of being resolved today or going toward a resolution today. It's being adjourned today because the prosecutor wants to adjourn it. So, you know, this is all a disadvantage to my client, Your Honor, and I'd ask the court not to revoke them.
yeah, all right, so I am going to revoke the bond. I consider that a serious bond violation. I'm going to set another bond. I'm revoking the $2,000 personal bond and setting the bond at 10% of $7,000. That's going to have to be posted within 24 hours, Mr. Crowley. If you're unable to post it, you need to turn yourself into the Taylor Police Department.
So I need
That's
$700 in 24 hours.
That's correct, Mr. Crowley. If you can't pay it, then you need to turn yourself into the Taylor Police Department within 24 hours.
Where do I pay it at?
It come to the district court, the Taylor District Court, and have that paid.
Your Honor, will you give me 48 hours and I'll have it paid?
No, I'm not gonna give you 48. I'm giving you 24.
All right, then, all right, I'll pay it, or I'll turn it in, or I'll turn myself in.
Same bond conditions as stated, no contact, direct or indirect, and that
Your
means
Honor,
social media or, I'm not trying to argue with you, I'm just, and, you know.
I get it, yes, sir.
You understand the bond conditions and
Yes,
being
yes, Your Honor, I
reinforced, so
do.
you have a little more skin in the game if you decide to violate.
No, I'm not violating anything. This is all made up. I'm smart enough not to put myself in peril. I want the court to know that. I am smart enough, I'm disciplined enough not to put myself in, I know better. I would not put myself at risk for jail time. Period.
All right, anything else?
Nope, I'm good, Your Honor. I'm gonna go get this money.
All right, good deal. Thank you. And you'll be notified of the pretrial date.
All right, thank you. Thank you very much, Your Honor.
2 weeks later.
All right, this is 250334 SM, the People versus James Crowley. All right, so Mr. Crowley, the prosecutors indicated she intends on charging this as a felony, but she doesn't have what she needs yet to do so. Do you understand that?
I do.
Okay, and now what was it you wanted to say to the court, sir? My understanding is you do not want a lawyer. Is that correct?
I would like to terminate Mr. Gizicki as my attorney, and I would like to represent myself as of right now. And I would like to, can you hear me, Your Honor?
I can. Are you telling me there's been a breakdown of communication between the two of you?
I'm telling you that in no way, shape, or form has Mr. Gizicki done anything to develop a defensive legal strategy with me or take any maneuvers whatsoever.
Okay.
I'm not, okay.
So your plan is to represent yourself?
Yes, for the time being. Is it, Your Honor, am I allowed to represent myself for a time until like maybe I can find an attorney or get a court appointed attorney that I feel more secure and confident in?
Well, we have other court appointed attorneys here. Mr. Coots is here today. You can meet with Mr. Coots if you want to meet with Mr. Coots on the case. But I only have so many options at court appointed attorneys, which means you only have so many options. I mean, you have a right, sir, to have an attorney at any time. And if you want to retain an attorney, you can get anyone you want. But if it's an attorney that is a public defender, we have 3 public defenders available to represent you at this court. I have Mr. Coots, Mr. Gizicki, and Mr. Fanto.
Well, then I guess my intent will be to represent myself, I suppose, for the duration of your courtroom, and then I'll just seek an appointed if they get away with increasing this to a felony. Am I allowed to object to the prosecution's adjournment?
Well, we're here today for, what's the status of discovery?
So it has been sent out to counsel, Mr. Gizicki. But if he has fired him now, I would have to send it over to him himself if he's representing himself.
All right, you understand that, Mr. Crowley? Mr. Gizicki has your discovery. But if you are representing yourself, I mean, obviously it would be.
Your Honor, if I may, last week I asked Mr. Gizicki specifically about the discovery and the evidence that the prosecution is burdened of. He told me that he has not physically received a discovery package and that he only has the police report in his physical possession.
All right, well, the police reports are discovery. I mean, that is part of discovery. And the only other thing there may be is body cam, I assume.
Yep, I would like, Your Honor, every Taylor Police body cam. I would like every phone call that was ever made to the Taylor Police from Jennifer or anybody else. I want a record of, I would like a record, Your Honor, of how many times the Taylor Police has been to my home in Taylor in the last 4 or 3 years.
Okay, well,
part
I
of my
don't know
evidence.
that they have those records. Whatever discovery you're entitled to that's in the discovery order, you will receive.
Okay, all right, thank you. Okay, I'll receive everything, all right. And I would like to, is this the time I could address some concerns, like why I believe that my case should be dismissed today?
I mean, it's a pretrial. If you have a motion you want me to hear, then you can write up a motion or we can have an oral motion hearing. But the evidence in this case will be presented at trial. And if there's a pretrial motion you want to file, you're entitled to do that under law.
Okay,
But
so
no, I mean, we're here for a pretrial today.
all right, so I can't express myself verbally as to that. All right, copy that. Pre-trial today.
Has an offer been made?
I got witnesses. I got a ton of witnesses.
Wait. I'm asking the prosecutor a question. Go ahead.
I believe Mr. Gizicki and I had discussed it, but I don't believe there was any further discussion on it. I don't know of any acceptance. There was a bond violation recently, and I believe that was why those conversations got halted.
Okay.
Excuse me.
Your Honor.
Yes.
So the bond violation was ruled off a hearsay. I wanted to contest the witness that came forth, which is my own blood cousin. And Mr. Gizicki pretty much told me that I would be a fool and that he professionally recommends that I sit and remain silent as the witness defame my character. I got Romulus police stuff saying that I didn't have an issue. I can prove that she did this. My cousin made that bond hearing statement out of revenge, and I can prove it. I need Romulus police witnesses. I got all the information, Your Honor.
Okay.
I had to call the cops.
I've reviewed the bond hearing. I listened to the record on it. I'm aware of what the allegations were.
Okay.
And Judge Kirsten found a bond violation, and that was his ruling on the matter. So that's already been decided, sir. And a bond, I understand, has already been posted. So what we're doing right now is Miss Louie at this point is not ready to proceed on her felony case. It sounds like you're not interested in a plea offer. Is that correct?
I haven't even, my attorney hasn't approached me. The best that I know, to my knowledge, the prosecution has not offered me anything.
She said that her and Mr. Gizicki have been in discussions about a plea.
Mr. Gizicki, in no way, I give you my oath, Your Honor, that he did not say anything like that to me.
Well, he might not have told you yet because the offer, it's the only one that can make an offer is the prosecutor. Not me, not Mr. Gizicki, only her. So if she were to make an offer or they were negotiating an offer, he might not notify you of that until the actual offer's been made.
Oh, okay, I see. I understand. Thank you for your clarification, Your Honor.
Like if they're just having discussions about a potential resolution, he might not notify you until she actually says, here is an offer. He has an obligation as an attorney, once an offer is made, to notify you of that offer. So this is my thought. I'm not going to just, we're not going to just keep dragging this out forever. I'm setting a trial date. I see the complaining witnesses present. Defendants present. If you decide you want an attorney before this date, Mr. Crowley, you have got to notify the court. Because if you show up on the jury trial date, you can't show up on the day of trial and say, oh, and by the way, I want an attorney, because the attorney won't have time to prepare. So if you want an attorney, you have to let us know before this date so that that attorney can represent you.
Well, I guess I'm just going to go ahead. I'm just going to sink or swim by myself, Your Honor.
All right, well, I'm going to just tell you, Mr. Crowley, you have a right to do that, but I want to be clear on something. So lawyers go to law school, right? It's not fun. And then when they finish law school, they get this book. And this book is every rule you have to follow in court. There are rules of evidence. And without 3 years of law school, sir, you're not going to know them. So you're going to be upset because if you ask a question the wrong way and the prosecutor objects, I'm not going to allow you to ask the question. Like you have to follow the court rules just like an attorney would, right? And if you represent yourself, you're held to that same standard. So you might, like, I know people think they know what hearsay means, right? Because there's like a general definition of what people think hearsay is. And then there's actual real hearsay under the court rules. And I just want you to be aware, Mr. Crowley, you have a right to do it. I think it's ill-advised, but that's your choice. And we can set it for a jury trial.
Judge, if we may set a settlement next week as well, because I believe the warrant should have been submitted by that point.
All right, so Mr. Crowley, for now, what we'll do is I'm going to adjourn this for 1 week. Okay, we'll come back in a week. And at that point, if an offer is to be extended, it will be extended. So if there's an offer on your case, you'll find out about it next week. Whether that you want an attorney to discuss it or you want to discuss it directly with the prosecutor, that's your choice. Okay, and then after that, we will set our jury trial. And so we'll return. Your dates are 4/21 at 9 a.m. And that's for a settlement conference. Everyone can still appear via Zoom. If an offer is made or the prosecutor's moving to make these felonies, she has a right to do that. I don't know the evidence yet. I'm not supposed to. There will be a hearing where I get to hear all the evidence and make that determination, but it's not today. And then the jury trial date, I'm setting it now so we don't lose it. Jury trial date, the next day I have is July 25th at 9 a.m.
That was 9 a.m., Your Honor?
At 9 a.m. sharp in person. But next week, come on Zoom, okay?
All right. One thing, Your Honor, anything that's going to be discussed about me or a potential settlement, excuse me, or whatever, the prosecution's going to have to go through me from now on, please.
Well, you don't have a lawyer. You've waived your right to
an
attorney, so she'll have to talk to you. She'll have to.
Okay.
Well, that's how it works. That's how the court rules work. If you don't have a lawyer, she'll talk to you. So we have bond continues. Nobody's to talk to anybody.
Yep. Thank you.
4/21 at 9 a.m. settlement conference via Zoom. And then jury trial 7/25 at 9 a.m. in person. It's the first date I have available.
All right.
I can get his contact information from this.
And I'll put him in a breakout room. You can get that information from him, okay? Mr. Crowley, I'm going to put you in a breakout room so the prosecutor can come and get information from you.
Your Honor, thanks for being awesome. I appreciate you guys very much.
Well, I'm just trying to make sure everyone follows the rules. Listen.
Exactly. Thank you.
Miss Ashby, Mr. Crowley, my job as a judge is to make sure people understand what they're doing and to make sure that people show up when they're supposed to and that they do not violate my bonds. Okay? So everybody is to continue doing what they're doing, no contact, and we'll put Mr. Crowley in a room so the prosecutor can get contact information from him, okay?
Thank you, Your Honor.
All right, we're all set.
1 week later.
All right, we're on record. This is 250334 SM, the People versus James Crowley Council. Can I get your appearance?
Good morning, Your Honor. Sarah Neighborhood for the People, P88069.
All right, and Mr. Crowley, can you tell me your first and last name?
Good morning, Your Honor. My name is James Crowley.
All right, so we have a first issue. A couple issues here. The first is that the people are moving. Mr. Crowley, you've decided to represent yourself. Is that correct?
Yes, Your Honor.
Okay, and at this point, we're still talking about a misdemeanor charge. So this was the settlement conference day for today. I see the complaining witness is also present. Ms. Ashby's present today. We have a jury trial set for July 25th at 9 a.m. That'd be in person. I was presented this morning with a felony complaint, but the officer was unaware, is not available to swear it in this morning. So I'm continuing this hearing for a week. And in the interim, so that's my decision on that. We're gonna come back next week.
Is that going to be a settlement again, Your Honor?
Correct. And I mean, we have these other outstanding issues that we need to address, but I
Yeah, we
want
can
to talk about this protective order for a minute. So I reviewed the protective order. 99% of this is standard protective order language.
Okay.
Whether it's a defendant or a defense attorney, the order is clear. It applies to both the defendant and counsel. And what the order says is that to protect the privacy and the sensitive nature of the documents, and it's all documents that could be included in the discovery, and that if they're given to the defendant, they cannot be disclosed or posted to any third parties via social media or digital means, which means, Mr. Crowley, if you get a copy of discovery, you can't post it on the internet.
Your
and you
Honor,
can't share it with people.
if I may, nobody can keep a secret in your courtroom better than I can, Your Honor.
Well, here's
I'm
the
not
thing,
gonna-
Mr. Crowley, though, you just said that you felt that this violated your confrontation rights to
Yeah, it
confront your
does.
complaint. It does not.
Okay. Well,
How
I
do you?
still. Okay, I believe that if I sign that, I'm hindering myself with regards to being able to question people, do that whole cross-examination thing. I got to be able to investigate as my own attorney. And I'm just not going to sign it, Your Honor.
All right, well, I mean, you don't have to. I can order it whether you sign it or not. I mean,
Okay.
all the prosecutor's asking is that you not disclose the information.
Yeah, I
right?
won't. Yeah.
And that means you can't post it on the internet. You can't send it to your sister, cousin, brother, uncle. You can't send it. You can't harass the complaining witness with it. You can't send it to her mom. You can't. It's for you to prepare for your case. It's not for you to have a court to have a trial in the court of public opinion. It's not to be shared or disclosed.
Your Honor, I understand this, and I understand and respect the court's decision. I will honor the court's decision, but I do not want anything redacted. And that's what the prosecution told me that was for. If I sign that, that makes some information redacted to me.
Well, some information is supposed to be redacted. I mean, if we find out, if there's something in there about like, I don't know, this is an example where Miss Ashby is currently residing. You don't need that. It doesn't go to one of the elements of the offense.
Yeah.
If her driver's license number is in there, you don't need that information. There's information contained in police reports and in other discovery documents that there might be an eyewitness who gives their driver's license number. And that's not information that you would be entitled to in discovery, or social security numbers for all I know.
Yeah, no, I understand.
That is the type of personal protective information is the type of information that would be redacted. Information that you're not entitled to. So Mr. Crowley, when you present your defense, every offense has elements, right? And information that goes to those elements is stuff that must be given to you. Exculpatory information is information that must be provided to you. But identifying information relating to the complainant or other witnesses is not information that is to be given to you. I mean, and that is the type of information that would be redacted. Am I correct, Madam Prosecutor?
Yes, Your Honor.
I mean, that's the kind of thing that they take out.
Well, Your Honor, if I could get one of those proposals specifically stating that they want to redact those social security numbers, driver's license numbers, that's fine. But anybody who claims that they have evidence against me, I'm not redacting it. And I don't mean to be disrespectful to the court, but I'm not signing it.
All right, well, you don't have to sign. I can order it without your signature. But let me go over one thing in the order that I did want to ask Madam Prosecutor about. On the last paragraph of page 2, it says that the information can be used for educational purposes by the Wayne County Criminal Defense Bar.
Yeah, Your Honor, this was a boilerplate motion or executive order we had. We can strike that.
I'm striking that. I mean, there's no, he doesn't have to agree to have his information become a tutorial.
Yeah.
Yeah, but they want it redacted.
Yeah, it has to be.
Yeah.
You've made your record.
Copy that, Your Honor. Can I move for a dismissal right now at this time, Your Honor?
I mean, you can move for one.
I would like to move for a dismissal based on discrimination in my case since February 3rd at the time that this has begun, based on the Constitution of Michigan in 1963, Article 1, Section 2, under the Equal Protection.
All right.
Everything in my personal experience with the police all the way to this moment since February 3rd, Your Honor, I'm on my 5th settlement in order for the prosecution to collect evidence against me. I'm on my 2nd bond hearing I had 1 bond hearing in which I didn't even defend myself because of my attorney. I've had an attorney I've had to fire because there's no defensive legal strategies whatsoever on my behalf. And I believe wholeheartedly that this is a direct violation of that Constitution of Michigan, Your Honor.
Okay. I've overseen this case since the case's inception. I did not do the original arraignment on the case, but otherwise the case has been in front of me for all proceedings. I believe myself to be fair and impartial. These are procedural hearings. This happens in every court case. So there's nothing unusual about the procedure. I'm not dismissing the case at this time. I am adjourning the case 1 week to bond conditions will continue. There is to be no contact with the complaining witness, and all other bond conditions that were previously put in place remain. I am entering the protective order. I am just asking the prosecutor to submit a copy. I'm not going to X out a copy. So I've X'd out the last paragraph on page 2. I want an order presented to this court consistent with the version I've signed already, so that we have a nice, clean protective order so that it can be provided to Mr. Crowley so that he can obtain discovery on this case.
Yes, Your Honor.
Thank you, Your
Okay.
Honor. Your Honor,
All right.
Your Honor, if I may ask you a question, please. I have a witness list that I would like to submit to the court. How do I give that to the prosecution, or do I just wait until I'm in the jury?
Well, we don't have a trial until July 25th. Okay, you have
Okay.
to submit your witness list within 30 days of the date of trial under Michigan court rules.
Oh,
So you can
copy that.
submit your witness list, and anything you send to the court, you must send to the prosecutor. That's how it works. Anything she
Okay.
sends to me, you have to get. I'm not supposed to be reviewing any documents that both of you aren't privy to without some sort of legal exception to that rule. So I'll enter the protective order when prosecutor provides. I'm just calling it a clean copy, but we know what I want, okay?
Yes, Your Honor.
All right, we'll see everyone next week, 4/28 at 9 a.m. Bond continues.
1 week later.
Okay, Detective Collip. This is 251195, the People versus James Lee Crowley. Can you raise your right hand? Detective, do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Can you state your name for the record?
Detective Philip Collip.
Have you read the type complaint that was filed with the court?
I did.
Are the facts stated in the complaint true to the best of your knowledge and belief?
They are. This is a supplemental from a prior misdemeanor that was for court today. That's getting amended to a felony.
Okay. Can you, are the facts stated in this complaint true to the best of your knowledge and belief?
Yes.
Can you state the facts that support the issuance of the arrest warrant?
On 2/3 of this year, at approximately 1:30 in the morning, Taylor officers were dispatched to 14603 Harold Avenue for a domestic assault. Dispatch advised that the defendant, James Crowley, was at the address destroying the home with a bat after becoming irate. Upon arrival, officers made contact with victim Ashby outside. Ashby stated that her boyfriend, James Crowley, was in the home, threatening to burn it down with everyone inside. Ashby stated Crowley was destroying the home with a bat and preventing her from calling 911 by hitting the phone out of her hands. Ashby stated that Crowley cornered her and prevented her from leaving the southeast bedroom of the home and continued to use the bat to destroy objects in the home. Ashby feared that Crowley would use the bat to hit her due to his erratic behavior and aggressive nature. Ashby stated that Crowley continued to make threats while holding the bat and used the bat as a means to prevent her from freely moving about the residence and preventing her from leaving through intimidation. Crowley was aggressive with Ashby and not allowing her to leave for approximately a half hour. Crowley went to the bathroom and Ashby was able to grab her keys and the cell phone and fled to call 911.
Okay. All right, let the record reflect, I find probable cause with the accused committed the alleged offense, and I'll therefore issue the warrant.
Thank you.
Mr. Crowley,
Yes, Your Honor.
you've been charged with the felony offense. Listen, there's an allegation that a property located at 14603 Harold Street in the city of Taylor, Michigan, 48180 on the date of February 3rd of 2025. The complaining witness says that on that date and at that location described, the defendant, that's you, contrary to law, did count 1, assault with a dangerous weapon, felonious assault. Did make an assault upon Jennifer Marie Ashby with a dangerous weapon, to wit, a bat, but without intending to commit the crime of murder or to inflict great bodily harm less than murder. You're also charged with count 2, domestic violence. The state of Michigan alleges that you did make an assault or an assault and battery upon Jennifer Marie Ashby, an individual with whom you had a dating relationship, contrary to MCL 750.81 parent 2. This is a misdemeanor, punishable by up to 93 days in jail and or a fine of $500. So, Mr. Crowley, the case against you has been amended to add a felony. You have a right to an attorney. And if you can't afford one, we'd appoint one. Do you want an attorney?
Yeah, I think it's best now that I get an attorney for this one.
It is the best. Okay. We will appoint counsel for you. We have to fill out some paperwork and your attorney will be in contact with you. And if not, they will be here on May 5th and you'll be able to meet with them then. Normally they call you ahead of time. And I'm just taking the bond on the misdemeanor case, and I don't have that file in front of me, whatever the bond was on the misdemeanor. Never mind, I have it. $700 cash bond that you filed will follow you over on this case. You have the same bond conditions, okay? You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. You're to have no contact with Jennifer Marie Ashby.
Your Honor, and what about when people have contact with me?
Wait 1 second, 1 second. Mr. Ashby, I'm sorry, Mr. Crowley, let me get through the things I have to say to you, because I need you to listen, okay?
Yes, ma'am.
You can't call her, you can't write her, you can't email her, you can't send her anything. You can't go to where she lives, works, or goes to school. You cannot have any contact of any kind. You can't have someone else do any of these things for you except for your attorney. You can't send text messages, instant messages, emails, tweets, or any other form of communication or contact her through any other social media site. If you have her programmed in your phone, delete her. If you send her a blank or empty message, I will
Your-
consider it contact since I'm instructing you not to do that. If the
Your Honor.
communication comes from you, Mr. Crowley, if you don't listen, you know what? Like some people are just waiting for their turn to talk. And Mr.
Yep.
Crowley, I have to say this to you, and I need you to stop thinking about what you want to say back to me and start listening and processing the information I'm giving you. Because if you don't process this information and hear me, and then you violate, you're going to jail. So this
Yes,
is
Your Honor.
important, okay? I'm trying to give you I'm trying to make sure you understand what no contact is, so that you understand that if there's contact and I put you in jail, you can't go, well, I didn't understand that, or I didn't hear that. Listen, okay? If you have her programmed in your phone, block her. You can't send her empty messages or blank messages. I will consider it contact. It will be a violation. It will not be a defense that you accidentally contacted her. If you go to a store, restaurant, or a party, for example, and she is there, you must leave immediately. If she contacts you, do not reply. This is an order of the court. The person named as the victim in this case cannot change, alter, or amend the order in any way. She can't change it, only a judge can. If she were to invite you over or ask you to meet her somewhere or contact you for any reason, you cannot violate the court's no contact order. And if you do, you will go to jail. If the order needs to be changed in the future, I will hold a hearing on it when both sides are present. Do you understand all of that, Mr. Crowley?
Yes, Your Honor. And I just want to reassure you and the court and the people, I have not contacted her. I'll give my telephone up to the state for tech to investigate my phone, everything. I have not. I don't want any trouble. I just want to resolve this as quickly as possible. This
Good.
is
All right.
ruining my life.
All right, Mr. Crowley, I have to tell you a few more things, okay? And listen, Mr. Crowley, you've been charged with a felony. And I told you at the beginning, you have a right to remain silent. You need to talk to your attorney before you start making all these statements, because you might say something that incriminates you.
Your
okay?
Honor, the truth
no,
can't
listen.
incriminate me.
Mr. Crowley, listen to me. I'm not fighting with you. I'm trying to help you understand your rights and understand what I expect from you. You cannot possess or have access to firearms. You cannot consume alcohol or illegal drugs. You can be subject to testing on demand at your expense. And those are your bond conditions for now, Mr. Crowley. We have 2 court dates coming up, May 5th and May 12th, both at 10:30 a.m. May 12th, you're to be in person, okay?
Yes, Your Honor.
And that other case, I assume, is going to be dismissed. And we'll just convert your bond from that case to this case, so you shouldn't have to post any more money.
Thank you, Your Honor. And so I'm being charged with felonious assault and domestic violence?
Correct.
Thank you.
All right, now, Miss Ashby, you also received those dates, May 5th and May 12th. May 5th,
Yes.
you can appear via Zoom. May 12th, you must appear in person. And Miss Dennis, would you like to speak
Yes.
with Miss Ashby in a breakout room?
Yes,
All
Your
right, we'll get 2 of you in a breakout room. And then Mr. Crowley, you should be all set for today. And
Okay.
you will, I'm going to, as soon as the prosecutor, unless you want to wait, the prosecutor is going to make a motion likely to dismiss this other case, and I'm going to grant that. So that's what's happening on that. And we'll see you back on May 5th.
All right,
Thank you, Your Honor.
Your Honor, I don't need to be present for that dismissal, I suppose.
All right, well, that's what I'm doing, and that's what I'm assuming they're doing. So we should be okay.
I mean, should I wait, or I don't really need to? It's the court. I don't really, it's all good. I don't need to be here for this.
I told you what I'm doing. What I'm doing is what I'm
Yeah,
doing. So it's
I
probably
agree.
good. It's on record.
Cool. Thank you very much, Your Honor.
Okay, yeah.
Am I dismissed now?
Yeah.
All right. Have a good day.